matter to come before the court this morning is State of Ohio versus Leroy McIntyre. Both sides will have 15 minutes to present an oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, wish to reserve any time for rebuttal, please let me know when you get started. I'm keeping track of the clock. You'll be also able to follow on the screen beside you. Please don't use the names of any victims or minors. We are going to be streaming this on the court's YouTube channel. We have read the briefs and we are ready to proceed when you are.
Is that all right? I'd like to reserve 5 minutes for rebuttal.
Certainly.
And may it please the court, my name is Stephen Hanadel. I represent the appellant, Leroy McIntyre. His real name is Louis Leroy McIntyre Jr., but in the case caption is Leroy L. McIntyre. This is an appeal from a denial of a petition for post-conviction relief. And I got to first preface all this is that I think, I think this court should address its 2018 decision which was the direct appeal, that it refused to consider all those assignments of error because, and since that time, the Ohio Supreme Court has come out with State v. Craig, which said that our position was right about the final appealable order issues in this case. And what that all means into this matter is that the post-conviction relief petition was timely. And in fact, the assistant prosecutor on the case in 2017 admitted that it was timely. And so therefore, all issues should be considered on their merits. However, a new development in the case law 6 months ago, actually 6 months ago today, that even if this court is to insist on sticking with its flawed reasoning from the 2018 decision in this case, and therefore consider the petition not timely, State v. Bethel, that came out in the Ohio Supreme Court 6 months ago today, changes the analysis in this case because there was a Brady violation, and the Ohio Supreme Court specifically said, and when it comes to petition for post-conviction relief and for Rule 33 new review trial motions. Now, Rule 33 is not part of this appeal. Had Bethel come out much sooner, back several years ago, we would have filed a motion under Rule 33, but just because it was in the pre-Bethel era, we did not file a motion under Rule 33. We filed it under a post-conviction statute. But under both standards, the Ohio Supreme Court said that when it comes to Brady violations, there is no due diligence requirement on the part of the defendants to obtain the information that was withheld by the state. And in this case, we have an affidavit from Mr. McIntyre's trial counsel, Vincent Meduno, in which he said under oath in an affidavit that there were portions of the police report that he did not receive, and all those portions talk about Tyrone Howard being a suspect in this case. And Mr. Meduno stated very explicitly in his affidavit that he was never advised by the state of Ohio that Mr. Howard was considered a suspect in this matter. And had he been advised as such, it would have changed everything in this case as far as how he would have pursued the defense strategy, the questions that he would have asked on cross-examination, the investigation that he would have conducted. And because let's remember, there were 2 assailants that committed these crimes in December 30th, 1990, and Mr. McIntyre was the only one ever charged. And it's rather odd that you got 2 assailants, but only 1 person charged, and especially now these police reports reveal that the police had another person that they thought had involvement with this. And this supports Mr. McIntyre's contention all along that Mr. Howard and his brother were the true culprits in these crimes. And because just before trial, and just to help tie this all together, the prosecutor filed a motion to call Lori Richardson as a court witness. And the reason behind that was that she was in a relationship with a, quote, suspected co-defendant. It was something to that effect. Well, a year later, she married Tyrone Howard's brother. And so, but yet, neither Howard brother was charged in this case. And so there's just a lot more questions and answers. And so that's why this matter needs to be sent back for an evidentiary hearing. We need to have witnesses testify. We need to have, Mr. Meduno, he's in his 70s now, he's living in retirement near Washington DC. I mean, and so far as I know, he's in good health still, but I need him to take the stand and testify and about what he knew and what he was advised by the state when he was doing, the defense for Mr. McIntyre at that time. And when you factor it in with all the other evidence in the case, as far as what when you look at what the state presented in trial to obtain a conviction, to at least obtain a guilty verdict, it was all eyewitness testimony, and including surprise eyewitness testimony that Mr. Meduno objected to in the trial itself. And so it was, and remember, these offenses happened in the dark of night, and what we now know in the 30 years since then, in cases where DNA evidence has been used to overturn convictions, many of those convictions were obtained by eyewitness testimony, and that eyewitness testimony has a lot of flaws in it. And the state had no scientific or physical evidence to tie Mr. McIntyre to these crimes, and it was purely on eyewitness testimony, and it's all the more odd in the sense that if they thought Tyrone Howard was a suspect, yet he wasn't charged, well, why didn't he testify? And there's a lot more questions than answers as far as how the police and the prosecution handled this case at that time, and those questions, they need to be addressed in an evidentiary hearing. And so, and no matter what standard the court wants to apply, our argument is that this post-conviction petition is timely, no questions about it, especially based on what the Ohio Supreme Court has said in State v. Craig in 2020. But even if this court doesn't want to consider it timely, State v. Bethel from 6 months ago comes in to apply, and therefore Mr. McIntyre is not held to a due diligence standard or any kind of unavoidable prevention of discovery because it is a Brady violation.
Counsel, did you cite State v. Bethel in your brief?
I'm sorry, can
Did
you
you
speak
cite
up?
State v. Bethel in your brief or submitted as supplemental authority thereafter?
I'm sorry, Your Honor, I didn't quite.
Oh, okay.
You said about State v. Bethel.
Right. Did you cite it in your brief or?
In the reply brief. So Bethel.
Okay. Thank you.
I filed my merit brief was filed in early
I
March.
couldn't remember, so you're good.
It is in my reply brief because Bethel came out while the briefing was going on. So like I said, no matter what standard the court wants to apply to the case in terms of the timeliness issue, obviously we prefer that it's timely. And I still love the position that there's still no final appealable order in this case based on the lack of disposal of the specification. I put it in the brief to preserve that issue, but ultimately, I'm here to talk about the substance of the post-conviction petition because, Mr. McIntyre has maintained his innocence in this case, for the past 30 years, and he vociferously has contested this on his own. He's never given up, and I know sometimes it's, his persistence can sometimes, just may come across as annoying to some people, but I guess if I were in his shoes, I probably would be doing the same thing. And it's, and I can tell you as an attorney, he's not always the easiest client to deal with because he's so persistent and he refuses to give up. And so, when Mr. Meduno's affidavit is the linchpin to this post-conviction petition, especially when you combine it with Tawanda Waiters' affidavit. She was known as Tawanda Tolles at the time. She was Mr. McIntyre's girlfriend, and there was an issue as far as getting her served with a subpoena and testifying at trial, and by the time she was made it to court, the jury was already deliberating, and she has put forth an affidavit stating that had she testified, she would have testified that Leroy was at her apartment at the time that these offenses were committed, and that she remembers that because she remembers hearing on the street about these two dope houses getting robbed at gunpoint. And also she provided some insight into who Mr. McIntyre really is. I mean, Mr. McIntyre was a boxer. He was in training to be a professional boxer at that time. This case cost him a professional boxing career. and he actually trained against Buster Douglas when Buster Douglas was training for the Mike Tyson fight that was still regarded as one of the greatest sports upsets of all times in early 1990. And so Mr. McIntyre was going to boxing. He didn't believe in using guns. Like he definitely got into fights in the streets. He definitely got into scuffles and as far as, beating people up with his fist, and that's what unfortunately attracted the attention of the Akron police lots of times. But he was anti-drug and anti-gun. In fact, when his I can't remember if it's in Mrs. Wader's affidavit, but when his sister was addicted to drugs at that time, he went over and beat up her drug dealer. So, and I believe that's in her affidavit too. And she provided some insight as to who he was, for better or worse. And so, when you combine that with Mr. Meduno's affidavit, when you look at the evidence that the state presented at trial, this needs to be addressed in an evidentiary hearing at the trial court level. And in regards to the police investigation, state's evidence, why wasn't Tyrone Howard charged if he was considered a suspect? And again, Mr. McIntyre and his attorney were not afforded that opportunity to address those issues. And
Counsel, you have about 4.5 minutes.
Okay.
You can reserve.
I will reserve my time.
Sure. Thank you. Counsel, Ms. Day?
Yes, thank you, Your Honor. Good morning, and may it please the court. I'm Jacqueline Corgan on behalf of the appellee, the state of Ohio in this case. And with respect, there are two reasons why the trial court's judgment should be affirmed by this court. First of all, even though it may not be a popular decision on behalf of Mr. McIntyre, this court's decision in 2018 cannot be revisited. That final order that the trial court issued in 2016 was final and appealable and this court's judgment saying that cannot be revisited for one simple reason at least, and that is because of the law of the case doctrine. That doctrine bars a trial court from disagreeing with the decision of a superior appellate court in that case. And then the doctrine also bars this court from changing its decision once the Ohio Supreme Court has declined jurisdiction to review that decision. That has happened in the 2018 case. The state of Ohio referred to that as McIntyre 3 in the course of the briefing. So once the Ohio Supreme Court declined jurisdiction in McIntyre 3, this court's decisions on all of the issues, became the law of the case that not only this court cannot disagree with, but also that the trial court was not empowered to revisit either. And for support, there's a series of cases out of the Ohio Supreme Court that hold that. I'm just going to refer you to Nolan, to Pipefitters, and Saline. Again, the two basic principles are that once a higher appellate court hands down its decision, the trial court can't disagree with it, and once the Ohio Supreme Court declines jurisdiction, the trial court can't disagree with the appellate court's decision, nor can the appellate court revisit its decision.
Counsel, you spoke of Nolan. Doesn't Nolan also, though, say that the doctrine is considered, law of the case is considered to be a rule of practice rather than a binding rule of substantive law and will not be applied so as to achieve unjust results?
That is correct. And there would not be an unjust result in this case under the existing case law from the Ohio Supreme Court to continue to to decline Mr. McIntyre's invitation to revisit the 2018 decision in McIntyre 3, because substantively, this court got it right. The February 2016 journal entry that the trial court had issued did resolve everything in Mr. McIntyre's case, met the requirements of Criminal Rule 32 to be a final or appealable order, because it addressed the supplemental indictment count 1 and its gun specification 1 and memorialized Mr. McIntyre's sentence on that count and that specification. it memorialized the fact of his convictions on all of the counts and specifications. It bore the judge's signature, and it bore the clerk's timestamp. That establishes it as a final appealable order. The Ohio Supreme Court's decision in State v. Craig does not change the analysis on whether this is a final appealable order in this case. Craig only said that when you have an order that does not resolve all the counts of the indictment, then you don't have a final appealable order. It did not overturn the Ohio Supreme Court's decision in Rodriguez or its predecessors that hold that a court's failure to address a specification, which is different from a count, it only deals with the level of punishment, or the degree of punishment, or the amount of time that a person is going to serve, is not the actual count itself. So Rodriguez holds a count is not a specification, and a specification is not a count. And a failure to address a specification does not affect the finality of the order. And regarding Mr. McIntyre's arguments in the brief concerning the verdict form for the aggravated burglary that had language that said that the gun specification dealt with a felonious assault, verdict forms are construed to make sense. And that's under McNichol from the Ohio Supreme Court, issued the year before my father was born, so back in World War II. So mistakes don't invalidate a verdict where the jury's intent is clear. And with this particular verdict form, the words felonious assault appear in this specification that is on the same verdict form as the verdict for the aggravated burglary. So from that, the listing of felonious assault is essentially a typographical error, and it is yet clear from that verdict form what the jury intended, and that was to find that Mr. McIntyre had committed the aggravated burglary with a firearm. Therefore, that's the specification. And this is especially true because the jury, you have to remember, did not find Mr. McIntyre guilty of all the felonious assault offenses with which he was charged. That jury was careful not to convict him of all, it was careful in reviewing each one. But the second reason this court should affirm the trial court below is that the trial court on the merits correctly dismissed the post-conviction relief petition. And the Bethel decision does not actually assist Mr. McIntyre in this regard. Bethel found that when a defendant can make a valid Brady versus Maryland claim, that means that he could not, it was impossible for him to have discovered newly discovered evidence through reasonable diligence prior to trial in order to file an untimely or successive post-conviction relief petition or motion for a new trial. But that court held the defendant still has to meet the burden of showing an actual Brady violation. In other words, the allowance to file an untimely or successive motion is not as broad or automatic as Mr. McIntyre would have this court hold. And in addition, Brady reminds us the defendants must also meet, or Bethel, I'm sorry, reminds us the defendants must also meet the second prong of the statute regarding the allowance to file an untimely or successive post-conviction petition based on newly discovered evidence. And that is that the defendant must not only show that it's newly discovered evidence, but it also has to present a clear and convincing evidence that without the alleged error, no reasonable jury would have found him guilty. In the Bethel decision, the court said that Bethel did not meet that burden. And Mr. McIntyre can't in this case either, for a few reasons. First of all, multiple witnesses identified him as one of the assailants in this case. And as far as the surprise testimony, reading the trial transcript, it is clear that the only reason that was surprise testimony from that witness was that she was never asked to identify the people that she saw getting out of the car. She was just never asked by police or anyone else. So when she identified Mr. McIntyre as one of two people, including TH, as getting out of the car to go and commit one of the offenses, the only reason, like I said, that was a surprise was because no one had asked her. But in addition, what Mr. McIntyre has presented, he talks about having questions, but that's all speculation and questions, and neither speculation nor questions amounts to evidence, much less clear and convincing evidence. In addition, I know Mr. McIntyre had briefed the issue that his post-conviction petition should have been evaluated by the trial court under the lenient pleading standards of Civil Rule 8. Unfortunately for him, this is not a civil complaint. Even though post-conviction petitions are considered to be quasi-civil actions under Civil Rule 1, those rules, or the civil rules, do not apply to situations where they clearly must not apply or cannot apply. And post-conviction relief in Ohio is well established as a creature statute, and that because of that, the procedures that are listed in the statutes from 2953-21 through 23, those are the procedures that have to be followed. There is some application of the civil rules in terms of discovery, if discovery is permitted by the court, but the post-conviction petitioner is required to meet standards under 2953-21 that no civil plaintiff is required to meet under Civil Rule 8. So those standards under Civil Rule 8 and 12b-6, which would require the trial court to assume that everything that Mr. McIntyre presented in his petition was true, that does not apply. Instead, we still have to follow the statutory standards for post-conviction relief, and they're different, and Mr. McIntyre just did not meet them. And in addition, I would like to let the court know just a couple more things. First of all, there is really no Brady violation here. TH's involvement as Mr. McIntyre's accomplice was already known to the defense. It's clear from the trial record that it may have been a surprise to Mr. McIntyre's trial counsel that TH was termed a co-defendant, but it was clear that Mr. McIntyre was one of two people who committed these offenses. And also, defense counsel, made that statement. She had never heard of him as being termed a co-defendant before. Prior to testimony beginning, defense counsel managed to cross-examine LR about TH being with Mr. McIntyre in borrowing the car used in the home invasion. I would refer you to the trial transcript of pages 76 through 77. Defense counsel crossed the same witness about her relationship, her romance with TH's brother, so that was known to counsel prior to trial. The only new thing, again, arguably, was labeling TH as a co-defendant, when truly he was already known as being an accomplice, even though he was apparently not arrested or prosecuted for the offense. But even if that label was new, that disclosure of TH being labeled a co-defendant constitutes a delayed or not a denied disclosure to the defendant. And the defense counsel had the opportunity to use it against the police witnesses in this case, and did not. So that information was not actually withheld permanently, which is what you're looking for in a Brady claim. You're looking at information that was never given to defense at a time when the defense could use it, which generally means before trial, or it means at a point where, for instance, defense has not had the opportunity to cross-examine the witness with whom it would be appropriate to discuss that information. This was, if it was considered a disclosure, it was done prior to any of the testimony in this trial, and defense counsel had the opportunity to cross-examine the police witnesses concerning it and did not. The information further was not material. Whether Mr. McIntyre had an accomplice did not diminish his guilt. And so it was also neither exculpatory nor impeaching. So there's no Brady violation in this case. But finally, my second and last point in the minute I have left is that this petition nevertheless was still successive and untimely, and again, Bethel does not release that, or does not change that calculation. It was untimely because at the latest, Mr. McIntyre had 365 days from February 18, 2016, when the transcripts from his trial were sent over with all of the other documents that were part of the trial court's case when he took the appeal in McIntyre 3. Now, the post-conviction statutes dictate when the time frames to file a post-conviction relief petition, and it calls not for filing of the record or certification of the record by this court. It speaks to filing of the transcripts in the case in this court. That's what starts the time ticking. And while my predecessor counsel may have thought it was certification of the record, with respect, that's not what the statute says.
Thank you, counsel.
Thank you very much, Your Honor.
Thank you, Your Honor. I think an important point you make is that in the Ohio Supreme Court talked about this in Bethel, that the ultimate question is, as far as the constitutional standard that's to be used to measure the merit of the post-conviction petition, does the evidence put forth in there undermine the confidence in the outcome of the verdict? Does the Brady material undermine the confidence in the outcome? And that's what the U.S. Supreme Court has established over the years in the cases subsequent to Brady, and that's what the Ohio Supreme Court relied on when it clarified what the law is in Bethel. So, because the Ohio Supreme Court conformed the interpretation of the post-conviction statute and Rule 33 to the constitutional case law that has been put forth by the United States Supreme Court, and that ultimately to satisfy the constitutional violation standard in the post-conviction statute, all Mr. McIntyre has to show is that the confidence in the outcome of the verdict is undermined. And absolutely, we do show that in this case because, as far as what Mr. McIntyre knew on his own or knew through his own efforts is irrelevant, because it's all about what did he know that the state knew. Did the police or the prosecutors consider Tyrone Howard as a suspect? I mean, Mr. McIntyre could suspect all he wants on his own, like, oh, I think it could be this guy or that guy. But as far as what the police knew and what they considered, that makes a huge difference, because when those officers are on the stand testifying for the state and Mr. McIntyre has an opportunity to cross-examine, it makes a huge difference that he knows that they considered somebody else as a suspect, and then have those police reports handy to conduct a fuller cross-examination as to the credibility of their investigation, and start asking questions. Well, gee, why wasn't this person charged? Why did you charge Mr. McIntyre? Well, you don't have. There's a lack of physical, scientific evidence linking Mr. McIntyre to crimes, but yet, what is it about Mr. Howard that you think is a suspect? I mean, there's all kinds. Like I said, there's more questions than answers And the fact you have these abundance of questions, that undermines the confidence in the outcome of the guilty verdicts. And that's ultimately what the post-conviction petition shows and demonstrates, and that's what merits an evidentiary hearing to be conducted to fully develop the evidence with testimony. So, so again, it's all about what did trial counsel know that the state knew at the time, and because that's the crux of the Brady violation, is what, did the state share everything it knew about the case to Mr. McIntyre's trial counsel? And the answer in this case was no, they didn't. So, we got one more minute here. And I should also point out too that, there was sometime in the 90s, it's in the post-conviction petitions, there was a post-sentence investigation report done by the Ohio Department of Corrections in which they talked about in there that, that Tyrone Howard was considered a suspect, and they prefaced all that saying that they got that information from the prosecutor's file. So that's even more evidence that the state was well aware, the police were aware, the prosecutors were aware at that time, and so, in the fact that Mr. Meduno was willing to come forward and say, I never got this information, and let's remember this too, the relationship between Mr. Meduno and Mr. McIntyre did not end well. It ended very poorly in a public spectacle, and so Mr. Meduno really does not have a whole lot of lost love for Mr. McIntyre, but at the same time, he's telling the truth. I mean, and that's all he's interested in doing. He doesn't really have he's not looking to help him nor hurt him. I asked him for information, and he felt an obligation to provide the truth, and that's what he's doing.
Thank you, Counsel.
Thank you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed by the clerk of courts on the day it is released, as well as posted on the House Supreme Court website. Thank you.
Thank you.